Good afternoon, everyone. My name is Steve Jewett. I'm a county court judge from Orange County, Florida, Orlando. Next.
Good afternoon. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada.
And good afternoon from Oregon. My name is Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals.
All right, and we're doing unit, I'm sorry. You guys can introduce yourselves.
Okay, I'm Olivia Brown.
I'm Pratham Soni.
And I'm Kai Waddell, and we're from Lincoln, Nebraska.
Okay. Is that the teacher?
That's me.
All right. Okay. All right. We're here for Unit 5, and we're doing question 1. The question reads as follows. A result of the decision in Wisconsin versus Yoder is that any, quote, parent, guardian, or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs, end quote. Do you agree or disagree with this result of the decision, and why or why not? Second of all, what words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And finally, how have courts balanced religious beliefs with other rights? If you could give us your opening statement, please.
We disagree with the decision in Yoder as a whole due to the determinants that many of its practices can have on society as a whole. The decision in Wisconsin versus Yoder stated that any parent could keep their child out of school after 8th grade with a religious exemption. However, an 8th grade education meant a lot more during those times than it would now. While I generally agree with the First Amendment's principle of freedom of religion, someone with an 8th grade education in today's society would be put at a severe disadvantage in comparison to their peers. Furthermore, the determining validity of a religious objection is difficult in and of itself is difficult, and the federal government has denied this ability in previous instances. For example, in Bob Jones University versus US, the Supreme Court determined that the federal government was able to revoke the religious exemption of institutions that participated in significant discrimination against African Americans. This was due to the fact that Bob Jones violated the fundamental national public policy and that there was an overriding governmental interest prohibiting racial discrimination with such governmental interest in the education of the general population. In my opinion, it is also such an interest.
While the Constitution doesn't explicitly state education as a right, there are a lot of areas which can be interpreted and applied to education. For example, the 14th Amendment requires equal treatment of all citizens, and in Broward v. Board of Education, the Supreme Court stated that since education was offered as a public service in Topeka, Kansas, it had to be equally offered to all students. However, more generally, the U.S. does not have a right to an education in its Constitution, as San Antonio Independent School District v. Rodriguez determined that there is no fundamental right to an education in the U.S. Constitution, and that the duty of it must fall to the states As a result, because D.C. is ruled by the federal government, there is no right to a public education in Washington, D.C. Many have specific provisions that outline a right to an education. Both Colorado and Wyoming have constitutional requirements that require thorough and uniform public school systems to be established, causing conflict in state courts over the definition and execution of such vaguely worded claims. Nebraska also has such a constitutional right, conferring the right to an education in common schools between the ages of 5 and 21 years old. States like California and Delaware have minimum but outdated funding requirements for their school system, with California requiring $180 per pupil to be spent and Delaware requiring $100,000 for the system as a whole. These modern numbers are closer to 9,000 and 2 billion respectively.
The courts have balanced religious beliefs with other rights in many ways. The Free Exercise Clause does not protect all religious exemptions. One cannot simply claim that murder, rape, or violence is a part of their religion and get an exemption for following federal or state law. The First Amendment also protects a citizen's right to exercise religion freely, but like almost all other rights given in the Constitution, the government may violate the right for the benefit of society or if they have a compelling state interest. An example of religious exemptions is from vaccination. In Nebraska, religious exemptions from public school children are allowed because many believe that it is in line with the Free Exercise Clause. However, other states see it as a danger to public health. Additionally, if a law that infringes on someone's ability to exercise their religion is neutral and applies to everyone, it can stay in place. Employment Division v. Smith ruled that the illegalization of peyote, a powerful hallucinogenic, was legal even though the drug was used for Native American religious ceremonies. It was allowed because it was a neutral law that applied to all citizens and did not in any way show that it was targeting the religion of the Native Americans. In the Church of Lukumi Babalu I, Inc., the city of Hialeah, a law concerning animal slaughter was brought into question. The law was passed in an area of Florida where the practice of Santeria, a religion that used animal slaughter, was common. The law outlawed only certain types of animal slaughter, and some justices saw it purposefully opposing Santeria. For those reasons, the law was declared unconstitutional.
All right. What does the separation of church and state mean?
The separation of church and state means that the state needs to acknowledge religious freedom, and therefore the state cannot allow religion inside itself. So, for example, there cannot be legislation passed that would uphold one specific religion over the religion of anything else.
Yeah, essentially it's saying that because we have the right to practice any religion that we prefer, some like people have different religions. So at a state level, a state cannot advance one religion in one way or another. And this has been shown in various court cases where in public schools, you can't have a prayer. Whereas maybe in a private school that is based around a religion, you can't have a prayer.
And I think a great example of the separation of church and state in law is the Lemon test that has been used, in several Supreme Court cases, specifically Lemon v. Kurtzman, where they're talking about the government specifically advantaging one religion, the law actually being targeted toward that religion or towards people who don't follow that religion, and many other things that are part of the Lemon test as a whole. So it has to be the government substantially supporting a religion that would interfere with like the freedom of religion or separation of church and state.
Okay.
What are the advantages and disadvantages of having an established religion?
Well, I would say, some of the obvious disadvantages of religion is, religion is a very personal issue to an individual. That's why there are so many different religions. And because the nature of religion is so connected with the soul and the mind, that people believe different things. And so a disadvantage of having a common religion is that some people are left out, and then their rights to practice said religion are not protected.
Yeah, off of what Olivia said, I also agree with this statement. We can see many historical examples of where there has been one specific religion, and it's caused a lot of damage to the people who don't conform to that specific religion. For example, we can see in the countries in the Middle East that conform to the religion of Islam, they specifically target people who do not conform to that, and therefore it's like hurting people and it's hurting their freedoms. And the United States and the Declaration of Independence was founded on the idea of pursuit of happiness. And if you're not able to express your own religion, you're not able to pursue happiness.
I think specifically where we can sort of see the advantage of an established religion when it comes to the government interaction with religion in the first place. So for example, many established religious institutions receive tax breaks or things like that and have a non-exempt status as an institution. However, with a non-established religion, or until it gets recognized as a religion by, say, the IRS, they don't actually have those advantages until that gets put into place. So I think that's the advantage of established religion in terms of like a legal context, is that they have a sort of set up interaction with the federal government.
Yeah, I would agree with Kai. One of the advantages of an established religion is just that you're able to, like, if you put everybody in one camp, you're able to better protect the rights of that camp and better kind of understand what that religion is.
You mentioned employment division versus Smith in your prepared remarks, and currently there's a number of cases addressing where people are arguing that rule of law should be modified to allow exemptions from, say, the neutral anti-discrimination laws to accommodate religious beliefs. Do you agree that the test in employment division v. Smith should be modified to allow more exemptions for religious freedom, or not, and why?
I definitely agree with the idea that I think employment division v. Smith should be modified in its decision, simply because the idea of assessing a law or something as religiously neutral is very difficult to do. I mean, court lawyers, cases, justices, things like that, all have their own biases, and it's difficult to really implicate what exactly has an impact on a religion until it actually becomes the precedent itself. So I think there does need to be a modification made, more so instead of making it a blanket statement like in an employment division v. Smith. I think it does need to be on a case-by-case basis. What is the religious exemption that they're asking for? How does it impact the general public? and other questions that need to be asked instead of making it a blanket sort of decision like employment division Smith was.
I would somewhat disagree with Kai here because I believe it is easy to identify. And although there are case-by-case bases in which you would need to like identify whether or not something is against someone's religion, you need to also understand that there are basic and fundamental things that you cannot do. For example, murder is unjust. It's against the interests of all people. Therefore, we need to have specific ideas which are kept and not like modify them in order to like stop specific ideas from happening and like specific extreme ideologies from happening.
I think I fall somewhere in between my two partners here. I think I'm a little bit wary to necessarily go into whether or not that should be modified. I think there's no problem in looking at more specific cases. I do think that's a smart idea where you can truly understand like, is this too much of a blanket statement? But I think it's a good rule of thumb, an illegal substance like a hallucinogenic should not be allowed. It is truly in the compelling state's interest to try and protect the health of its citizens. And so I think that a hallucinogenic, which is very well known to cause health problems detrimental to your health, I just don't think it's smart to really try and toe the line of what substance is okay to use, what substance isn't okay to use, especially when it's something revolving around your health.
Okay, I do have a follow-up for that, but I got another question that I want to ask. How should a student's right to education be weighed against a parent's right to impose their religious beliefs on a minor? And specifically, I mean, that's what happened in the Yoder case, because the parents were Amish and they felt that their child did not need to go to school. Let's change the facts and say that that's what happened, but the kid wanted to go to school. How should that be resolved?
Well, and that's actually that was a big problem for me answering this question, because religion is such an individual choice. Say the student didn't consider themselves to be Amish, but the parents made that decision for them. At some point, everybody has to make their personal decision to take ownership of their religion or the lack thereof. And so I think that at an 8th grade level, if you only have an 8th grade level, you're not able to truly function outside of possibly an Amish lifestyle. You might not be able to do anything other than just farm on your land. It's significantly harder to get a job without a high school degree or even a college degree you need now. So I think that if the kid wanted to go to school, he should have been able to. I don't think it's really the parent's right to force a religion onto a child. I think that that's more of an individual decision. So I think that students should have the choice to stay in high school, even if it goes against their parent or guardian.
I somewhat disagree with Olivia here because fundamentally, if you're not 18, you shouldn't be able to make that specific decision about something because it's like your parents' choice and you still have a lot of education.
But about religion, it's a personal choice. Your parents can't choose that for you. We can still have independent thought at the age of even like 13, 12, 11. It's different for each person. So I don't think you can overgeneralize that.
Yeah.
Time. I had so much more I wanted to ask. Good job, you guys. As I say every time, but sometimes it doesn't apply as much as this. This is my 3rd time of doing nationals, and really, to me, the ones that are the best are when it's just like a conversation, and I'm drawn in, and the time I don't know the time because I'm just interested in hearing what your thoughts are, and that's where I was. You know, I wanted to go further with that last question I had, and you know, say, because the whole reason of Yoder was they said, well, this kid is going to be a farmer and he's never going to leave the farm and all that. And your point is exactly right. If he wants to go to school and he doesn't want to be a farmer, then he's going to be out of school when he's in 8th grade. And the next thing you know, he's leaving the sect and he's not prepared. To me, that's the real problem with the Yoder decision, is that it doesn't take that into consideration. But yeah, I had many more things I wanted to talk to you guys about. I'd love to, you know, to probe your brains on some of this stuff. One thing about your opening statement, you had so much information, but it was way too fast. way too fast. You guys were just rolling it out there. Now, maybe it's because my ears are old, but I was having difficulty sticking with you. So that's something to consider. Now, I know you only have a certain amount of time, and you want to make sure you get it all out there. I don't know how much time was left, though. If you left even 30 seconds on the table, if you could stretch that by 30 seconds, it's going to be a lot better, because you had good stuff in there. What I could hear and what I could digest was fantastic stuff. It was great. I don't really have a lot of things to point to. I think you did a fantastic job. Good luck.
Yeah, I thought you guys did a great job too. You answered the question. You answered it well. You were really clear from out the gate. You disagree with Yoder, and then you just gave example as to why. Starting out with just an 8th grade education is not sufficient, bottom line. And so I thought that you had great references to cases or to precedents throughout your prepared remarks. You clearly understood the constitutional principles, and you applied them well. When you responded to the questions, you each spoke so emphatically. You gave great examples. You all truly had your own viewpoint, and it came across, and that was, I just thought that was great. I didn't know whether or not this was staged or not, but the fact that one person, and I can't remember your name, started out with his opinion, and then I guess I'm going to say Protham said he disagreed, and then Olivia's like, well, I fall somewhere in the middle, and this is why. I thought that was great that you really thought about the questions asked of you, and you provided lots of evidence when you responded to them. I thought it was just really good, and yeah, we could have just kept talking, going on and getting your viewpoints in there. Olivia was really fired up about her response.
She didn't fall in the middle on that one question. She was like jumping in. No, I think you're wrong. Yeah, good job.
You really brought both knowledge and passion to this presentation, which was really enjoyable to talk with you and actually see you arguing amongst yourselves. Great balance and participation, great responsiveness. I appreciated on the first question about church and state that you actually tied it to the case law. I think as Kyle brought in the Lemon test there and explained sort of how courts figure out what the line of separation is. I thought the range, it was fun to watch your gears turning on the, should employment division, department division B. Smith be altered to allow greater exemptions for free exercise. So it's nothing to add apart, slow down in the opening remarks, but I did think your pacing was quite good. Oh, and you talked about taxes, which is not common among high school students, and I thought that showed a really sort of very sophisticated understanding of the role money can play in all of this as well. So great job.
Yeah, thank you. I did want to just go back and comment on it. I loved your response to the question with regards to whether or not there should be an established religion, because you answered it in a number of different ways, and that question could be interpreted a number of different ways. And you guys answered, and I thought, great response. I mean, you included a number of different perspectives, which really did demonstrate your grasp of the law and your understanding of the issues. I just thought that was a great response. So
yeah, on that issue, it didn't appear to me, and sometimes you can see it where, okay, they're ready for one sort of block, and they've broken it up. Like this person's going to say one thing, and this person's going to say another thing, and it's all supposed to be this one cohesive thing. I didn't see that. I just saw 3 people like, okay, this is what I think on that issue. So, and maybe I've been fooled, but I like that. I really did like that. All righty.
Good job and good luck.
Thank you.
All right, thank you very much for judging.
Bye.
Bye.
Thank you for doing what you
Bye-bye.
do.